Lawyers have read it. What's something most people only learn about the legal system when it's too late? Story 1. Special education case. A mother and the school were fighting about services. We got new assessments that backed up the mother's claims. The local school didn't have the right services, so we arranged a transfer to a larger school not too far away. There was a good public transit route and some extracurriculars the kid was excited about. She goes to enroll him in school, and they say they have a problem with paperwork. Thinking the transfer info just didn't get there yet, I take a copy and head down there. No, they won't enroll him because... not his legal name. She is not his legal mom. Turns out, she was the best friend of a mother who was pregnant and about to be incarcerated for drug trafficking. The best friend said, "Can you take my baby while I'm in jail? I'll get him as soon as I'm out." She and her husband said sure. They signed a piece of notebook paper. 12 years later. Shaking my head. You have to think, how did they manage to navigate school and medical stuff for 12 years with no legal custody paperwork? They'd just been using an assumed last name of the pseudo-adoptive couple. And, like me, no one had asked. It was only that the school had moved to an online system that checked social security numbers against other databases that it was caught. Anyway, the biological mom and dad were still alive and still in a lot of trouble. They consented to the couple that raised him adopting. The kid missed a week of school while I convinced them that he fit under a homeless youth school stability statute. Edit. Yes, it was the couple that had raised him those 12 years that adopted him. Story 2. Here's another. I wasn't actually an attorney yet. I was clerking for a firm and helping other attorneys on cases. We had a personal injury case for a car accident. A guy got rear-ended by a very wealthy doctor. He was never going to be able to work again, a male in his mid-30s. His life was completely ruined because she was staring at her phone while merging onto a highway going 15 miles per hour over the speed limit. Easy. The case was set for trial. That's an automatic red flag, as 99% of them settle. No one wants to risk the trial. We couldn't figure out why. We thought we would get him around $2.2 million. The other side was offering $700,000. So I'm going through the massive file trying to figure out what they have that we don't know about. Looking at his medical, I saw he tested positive for methamphetamine a few months after the accident. I was part of the jury selection that morning, and we had 2 people with doctorates, several with masters and professional licenses, and most were college educated. This was really not good for a guy who didn't make it through high school and was a laborer who decided to sit at home and smoke substances after his accident. Ended up settling right before the trial was supposed to start. We got a little more out of them, but far below what we expected. The guy was adamant about not settling, but we talked him into it. He would have been screwed as soon as they brought that up. Story 3. I worked in family law for a bit. Now I'm in personal injury. One case we got when I was a law clerk for a family law attorney was a guy who was a stay-at-home dad to 6 kids, while his wife busted her butt. They lived, essentially, on a farm. The oldest kid was around 13 and wanted to show cows. The youngest was around 2 years old. The point is, these people are stupidly wholesome. Except Dad comes to us for representation. Out of nowhere, he wants a divorce, and so far representing himself, it's gone completely sideways. His wife kicked him out of the house after claiming she would call the police and claim he was abusing her, so he left the house immediately and now lives in a small trailer on the property. A friend's. He's been separated from his kids for months. He spent tens of thousands on an attorney he can't afford, and now he's coming to us. We review his case and discover that he had, without an attorney, signed over full custody to the wife. He had also agreed to no visitation until a court-appointed psychologist could evaluate him. This was something he had no idea about, but the wife's attorney slipped in. He also agreed to pay child support for all 6 kids, again no job, and spousal support. In exchange, he got to keep his truck, which he lived out of before the trailer. The reason he had agreed to all this: I thought she would go easier on me if I was nice. He had no idea that everything he signed was legally binding. He thought it was more of a temporary agreement or something to get the ball rolling. He also thought he could change it at any time. Nope. We had to go to court to get any of that undone or even amended, and it cost him even more money he didn't have. By that point, he had to declare bankruptcy. His wife refused any kind of mediation, and her attorney was a shark. He ended up with partial custody, supervised visitation. The psychology evaluation found nothing wrong, but the judge wanted to be safe, and still had to pay child support for the time the kids weren't with him, so 50%. Spousal support was lowered at least. He also had to pay back child support because he hadn't been able to pay it for a few months. Again, no job. It was so sad. Story 4. 1. Yes, shut up, but shut up in 2 particular ways. Invoke your right to remain silent, and if you're being held in custody, say, "I am refusing to answer questions. I want an attorney." Do not equivocate. If you say, "Maybe I should talk to a lawyer," or "I think I need a lawyer," they are not required to get one and will try to talk you out of it. 2. Your Fourth Amendment rights are about how police can obtain information, not what information police can obtain. Want to be safe from your secrets being shared? Don't tell anyone who is not legally required to give you confidentiality. Lawyer, doctor, priest. 3. Your confidentiality with those parties is dependent on maintaining the confidence. They're not allowed to breach it, but you can easily accidentally breach it. If you talk about something with your wife, and your kid is in the room, there is no confidentiality. If you bring your girlfriend into the room to discuss something with me as your attorney, there's no confidentiality. 4. The police can and will lie to you. 5. Most of what you know about intellectual property is wrong. Just throwing that out there. 6. Talk to a lawyer early when it comes to contracts, estate planning, etc., especially if you have any kind of significant assets. Asterisk, asterisk, asterisk. Story 5. Attorney, you have very little privacy rights in your vehicle. If you're pulled over, the police officer can search the majority of your vehicle under the theory that the officer is looking for weapons in your immediate reach. Consequently, if you need to hide something, don't put it in the passenger compartment. However, if your car is impounded and subjected to a lawful detainment, for example, arrest, or even simply 24-hour hold, your entire vehicle may be subject to an inventory search. If the police officer suspects substances are in your vehicle, he may detain you for a period to wait for a substance-sniffing dog. The dog is not considered a search. Lesson: do not hide contraband in your vehicle. Story 6. Be very careful trying to interpret legal documents on your own, whether it's a contract, a statute, or the Constitution. A lot of words have very specific meanings that aren't necessarily what you think they are. And even words that generally mean what they mean in normal situations may have developed that very specific meaning through court decisions over the years. Do not assume that because you read a phrase or sentence to mean one thing, that a court will agree with you. Story 7. Doing some pro bono for the local legal aid, and they asked me to help this young couple with a squad of kids who were facing eviction. Sure, great. I met with a young couple and they were the most stereotypical entitled, mean trailer trash you can imagine. The mom mentioned she was disabled as I was going over the indigency requirements, and when I asked the nature of the disability, she replied that she, quote, couldn't read good. Okay, whatever. It turned out the notice telling them to get out was seriously deficient, so I figured this would be a super simple case of show up to a justice of the peace court with them, point that out to the judge, and be on my way. I explained to them that this was just a delaying tactic, and that the landlord could just post a new notice to start the whole process over, and they should move out before then to avoid an eviction on their record. They deserved to be evicted. They'd just stopped paying due to some personal conflict with the landlord. Anyway, Their day in court arrives, and of course the judge dismisses as soon as he sees my motion and the deficient notice. But in the meantime, I discover that the landlord is an elderly gentleman who is completely illiterate, so he had had someone else fill out the notice for him. Also, my clients were screaming taunts and insults at him in the courtroom and in the parking lot, and he had tried to tell the judge that they were threatening his grandchildren before it got dismissed. So I won, but I felt pretty bad about it. Story 8. There's so many posts here about people doubting themselves as lawyers, so I want to tell everyone a story. Yesterday I had a hearing downtown at 10:30 in the morning. I arrive around 9:45 in the morning at the court, where another lawyer, defense, was already waiting there for a pre-trial conference. The judge arrived shortly before 10:30 in the morning and let me know my hearing was delayed, because they couldn't find the plaintiff's lawyer. It was around this time that defense counsel piped up and said that this was the second time the plaintiff's counsel had no-showed the pre-trial conference. While we all waited for the plaintiff's counsel to show up, the judge explained how, apparently, there was a proceeding that same day to have some other lawyer disbarred. The rumor around the courthouse was that he had 4 separate grievances against him. He was an hour and a half late for his own trial. He also apparently began arguing with the judge. Finally, the plaintiff's counsel showed up to our courtroom literally moments before the judge signed an order, dismissing his case with prejudice. He had apparently failed to designate experts or submit any evidence of his client's damages and injuries. The judge candidly told him that if he proceeded to trial, he would have to dismiss the case on a directed verdict for this reason. The case settled on the record. I bring all of this up just to say, that typo you made last week, that exhibit you forgot to attach, that email you probably should not have sent, probably not a huge deal. You'll probably be okay. I'm not saying compare yourself to the worst, but my God. If you're minimally competent and making your boss's life easier, you're ahead of at least half of the lawyers out there. So don't be so hard on yourselves. Edit. As another commenter pointed out, these stories probably stem from internal struggles with these two lawyers, whether it be mental health, substance abuse, burnout, or some combination. You should always ask for help before getting to this point. Story 9. Hey guys, I wanted to come on here to tell my story and inform others of the experience and challenges I faced while getting a driving under the influence charge in nursing school. For your information, I live in Arizona. First, I just want to say to all the future nurses dealing with a driving under the influence charge, breathe. You will become a nurse. This is not the end. I know it's a traumatizing experience, but you will get through it if you never give up. For reference, I got my driving under the influence charge during nursing school, literally a month into it. So I passed my background check prior to even starting, since I had a clean record. Those of you with driving under the influence charges prior to nursing school, it really depends on the program you apply to, because some may or may not accept you, so make sure to do your research before applying. Anyway, on to the driving under the influence accident. I was about 5 minutes away from home when I dozed off and crashed into a curb. No, I didn't hit anyone or any private property. Police showed up and I was completely compliant with them and also blew. I think I blew a 0.10 and my blood alcohol content came back as 0.094. I immediately got an attorney because I knew ultimately I was going to get charged regardless. My attorney told me not to inform my nursing school of the driving under the influence arrest, since I haven't been convicted, so I flew under the radar and continued nursing school as if nothing happened. I am aware other nursing schools require reporting arrests, but mine didn't, so I didn't bother saying anything. Summary of my driving under the influence case. My specific case was prolonged for almost 2 years because I was busy with nursing school, and the court was understanding of that, thankfully. I got convicted during my last semester in January. I had to pay a $2,000 fine, spend 24 hours in jail, more like 15, 6 months with an interlock device, and no probation. I paid off the fine immediately and did my jail time, then applied to get the conviction set aside. I highly recommend getting your driving under the influence convictions set aside or expunged as soon as possible. I turned in my application, and the judge signed off on it in a month, but I heard it can take up to 3 months. Having that set aside will really help you when applying for your license, and for jobs in general. Throughout nursing school, my driving under the influence charge never was an issue until block/semester 3 when I was placed at Banner Health for clinical. This particular hospital ran an additional background check on students, so of course I didn't pass because of the driving under the influence arrest. This situation forced me to speak with the dean of my nursing school about the situation, because, as you know, if you aren't placed for clinical, you cannot progress in the nursing program. Luckily for me, my dean was surprisingly super understanding and placed me at a hospital that didn't do an additional background check, Dignity Health. I know everyone's nursing program director is not going to be like mine, so I honestly would not say anything unless you absolutely have to, especially in regards to clinical. Moving forward, I passed all my blocks and finally graduated this past May. Now I had to face the big dogs, the Board of Nursing. I had been dreading this part, but the only 2 things that were standing between me and that registered nurse license was the Board of Nursing and the National Council Licensure Examination. I was determined to conquer them both. I applied for my registered nurse license in April. On your application, you have to provide all court documents, a detailed essay of what happened, make sure to sound remorseful and say you're sorry, any certificates of completion, substance and alcohol education, Mothers Against Drunk Driving certificate, etc., optional but recommended. I got my authorization to test without any issues a couple weeks later in May, and scheduled to take my National Council Licensure Examination in July. Took the National Council Licensure Examination and passed in 85 questions. Usually by this point, once you pass, the Board of Nursing would immediately give you your registered nurse license. If you have a record, instead you get an investigator assigned to you to investigate your driving under the influence charge. So at this point, I had to provide my investigator with the full police report, court documents, a written essay of what happened, and any other important information all over again. Then the investigator will conduct a telephone interview. Be prepared to answer questions and don't say too much. The more you say, the more they can use against you. Just keep the conversation cute and casual yet professional. My investigator was cool, so I already knew I had this in the bag. Sample questions asked: do you have a family history of alcohol or substance abuse? When is the first time you drank alcohol? When is the last time you drank alcohol? Have you ever had any mental health issues? How did the driving under the influence change your life, etc.? The interview lasted 10 minutes. A month later, I got a letter in the mail saying I was approved, and got my registered nurse license a week after that in August. Now for job hunting. I was also really nervous about this part, but it was honestly the easiest part of the whole process. I got a job at a hospital on a medical surgical floor in September. I started in October and have been working for 10 months now. I love my job and my coworkers. I hope this helps someone out there who is going through the same thing. I know it's scary, but you will get through it. If you have any questions, feel free to ask me. Good luck. Story 10. Sorry in advance for the long post. I have a couple questions at the bottom. I am disappointed in the Washington State Victim Notification System, but am wondering if I still have a chance for justice. Editing because he still got arrested for murder. I was barely out of my teens when this all happened, and thought it would be taken care of for me. In 2014, I was physically abused by my partner at the time. I did not report it, but he ended up getting arrested 2 days later after our apartment maintenance person saw my black eye and called the police. An officer took photos of my face and had me write out a statement of what happened. I was stupidly still trying to protect this guy, so in my statement I mentioned that it was the substances he was on that made him do it. I did some Googling, and according to a page on the Washington State Court's website, it is the perpetrator, not substance abuse, not the victim, not the relationship that causes domestic violence. I also asked the officer not to press charges, and he explained that it is the state who decides to press domestic violence charges, not the victim. His mom bailed him out the next day and enrolled him in outpatient rehab. A month later, my abuser was arrested for harming a friend while on the same substances he was on when he hit me. He was convicted for the second-degree harm along with some other voyeurism charges or something from that same night, but I never heard about my domestic violence case again. No one from my local police department or county court ever contacted me to follow up. He is now about halfway through his sentence, I think. I never attended his court appearances or sentencing, so I have no idea when he actually will be out. I can't find anything on the Department of Corrections website about his release date or when he'll be eligible for parole. He still tries to call me to this day. I have the prison number blocked, but I have all the voicemails saved in a folder, and even sent a letter to me through his younger sister a few years ago. I have no desire to talk to him, and I'm afraid he'll come looking for me once he's out, since I still live in the same area. I signed up for Vine, Victim Information and Notification every day, after his conviction, a system that tells you when an inmate is transferred or released. However, I don't think it did its job because he transferred prisons a couple times and ended up calling me from new prison numbers that I had not blocked. It was traumatic for me to hear the recording of his voice when the call came through. I never once got a phone call, text, or email from this Washington notification system. The only reason I haven't changed my phone number is to monitor how often he tries to call me since I've lost trust in that notification system. He calls 4 to 6 times a year, as recently as September 2020. So here are my questions. 1. Is it too late for me to follow up on that domestic violence charge from 2014, since there are photos and statements on record? Will I need a lawyer even though it is the state who presses charges? 2. Is there any action I can take to make sure the state actually does what it's supposed to do, when it supposedly has a system in place to protect victims? I am still upset about never getting those notifications, and I now have to Google his name every couple months just to make sure he's still locked up at the same place. 3. Is there any way I can do all this without having to face him in person? I am absolutely terrified of this man. Thanks for any advice in advance. Asterisk, asterisk, asterisk. Story 12. So my most recent client came to me after a dispute arose over engineering and architectural plans and a failed construction project. So let's assume you are in a similar boat. You wanted to build a $20 million facility, and your contractor messed up and it collapsed. I would meet with you and discuss the case, and probably spend about 2 hours with you, going over all the facts. That's not build. You are not a client yet. I say, yeah, I can help you. Let me drop a retainer agreement. I go back to my office, drop the retainer agreement, and that takes an hour. I can't bill for that. So you send back a few minor changes. I review that. I can't bill for that. You are not a client. Finally, you sign the retainer and are now my client. I've probably invested 10 hours into you at this point and didn't bill any of that. I start billing when you start giving me documents to review, and when I start drafting a demand letter to the contractor, subs, etc. I need to get an associate on this matter so you are not being billed out so high. I spend 30 minutes getting Associate 1 up to speed. I can't bill for that. Associate 1 spends 10 hours drafting a pleading because he's new to this and doesn't know really what he is doing. So I revise it and give it back to him, and he spends another 3 hours on it. I can't ethically bill you 13 hours plus the 1 hour of my time for it because it should have taken 4. That would violate our code of ethics and might get me sued. So I eat 9 hours of time and write it off your bill. So, in 30 hours of work for you at the outset, I could maybe bill you 8 to 12 of that. Story 13. I had a client who would complain about every item on her bills, right down to the FedEx charges for the unimportant crap she insisted I overnight to her. So once when we were at court, I had to stop by the law library and look something up. Sure enough, she started asking about some type of research. on some issue that I'd had to do on her case. Her point was that, well, it's all in the books. Why do lawyers have to charge for that? I took her over to the 8 shelves of books in one section of the library and said, "Do you see that? That's the California codes. This here," pointing to 1.5 shelves, "is the Code of Civil Procedure. This is all the rules for moving a case through the courts. Everything you need to know is in these shelves." Oh, wait. Or maybe not. Maybe it's over here, in the shelf of the California Code of Regulations. Or it's case law, which is that entire half of the library. Hold up, there's an issue arising under federal law. That's the other half of the library. And, although I might not have all these laws committed to memory, I know where they are and how to find them. Kenya. This is why I'm not mad about paying an electrician $300 to come over and fix stuff, or paying for a brake job. Maybe I could do it myself, but I'd spend an entire Saturday doing it and it would suck. They know what they're doing and can do it in 45 minutes. They get paid. So should I. Story 14. A. Just how overloaded the system is. B. People see Law and Order and think they will have the trial within a week of the crime. Nope. Even for misdemeanors like shoplifting, it is a minimum of 3 or 4 months. C. Where I work, the court has 6 days a month for trial, and I have 200 new cases a month. I have to share those 6 days with 10 other attorneys in my office, and there are 10 offices in the county. D. The courts are so overloaded that we plead out 99% of our cases. If even 1% more people took their case to trial, the entire system would collapse. E. The police can lie to you. They can tell you that your buddy ratted you out, or that they have your fingerprints, or that they have video of you doing it. They can lie to you to get you to confess. F. The police do not have to read you your rights when they arrest you. They only have to read you your rights if they want to interrogate you while you are in custody. If they arrest you and don't ask you any questions, they don't have to read you your rights. G. If you are read your rights and you say you want a lawyer, the police can still ask you questions. They just can't use your answers in court, but they can use them to find other evidence or to get you to confess later. H. If you are arrested, you have the right to remain silent. Use it. Don't talk to the police. Don't try to explain yourself. Don't try to talk your way out of it. Just shut up. I. If you are arrested, ask for a lawyer immediately. Don't answer any questions until you have a lawyer. J. If you can't afford a lawyer, one will be appointed for you, but it might take a few days. In the meantime, shut up. K. The public defender is not a bad lawyer. They are overworked and underpaid, but they are good lawyers. They know the system, and they know the judges and prosecutors. They can get you a better deal than you can get for yourself. L. The prosecutor is not your friend. They are not there to help you. They are there to convict you. M. The judge is not your friend. They are there to make sure the trial is fair, but they are not there to help you. N. The jury is not your friend. They are there to decide if you are guilty or not. They don't care about you. O. If you are innocent, you still need a lawyer. The system is not perfect. Innocent people get convicted all the time. P. If you are guilty, you still need a lawyer. They can get you a better deal than you can get for yourself. Q. Don't represent yourself. It's a bad idea. You don't know the rules. You don't know the law. You don't know the system. You will lose. R. Don't lie to your lawyer. They can't help you if they don't know the truth. S. Don't lie to the judge. They will find out and it will make things worse for you. T. Don't lie to the jury. They will find out and it will make things worse for you. U. Don't lie to the prosecutor. They will find out and it will make things worse for you. versus don't lie to the police, they will find out, and it will make things worse for you. W. Don't lie. X. The legal system is not fair. It's not designed to be fair. It's designed to be efficient. Y. The legal system is not just. It's not designed to be just. It's designed to be efficient. Z. The legal system is not about truth. It's about what you can prove. Story 12. Location: Texas and Kansas. Imagine sending your child for visitation with their other parent, someone who had been largely absent from their life, only for them to refuse to return your child. Then, despite having a custody order in place, you're told it's not enough to get your child back. You must hire a lawyer, file a writ, and spend thousands just to enforce what should already be upheld by law. Even then, you discover that if the other parent still refuses, the police won't intervene. Then, to make matters worse, a false protection from abuse (PFA) case is brought against you in a state that doesn't even have jurisdiction. Instead of following the law, the courts are determined to push it through under quote 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 quote, which they have no legitimate grounds to claim. This is my reality. When I was 17, I entered a relationship with a girl from my school. Let's call her Shanae. We dated briefly, broke up, and then she told me she was pregnant. Given her reputation, I had doubts, but a DNA test confirmed that I was indeed the father. From that moment, I knew I had to be there for my son. However, from the start, Shanae made that incredibly difficult. She used our son as a control mechanism, once telling me, "As long as you act right, you'll be able to see him." That statement foreshadowed a years-long battle. In the early years, she had primary custody while I went to college. I visited my son whenever I could. By the time he was 3, she willingly signed over custody to me and my parents, unable or unwilling to take on the responsibility. For the next 2 years, she was largely absent. When I prepared to transition my son to live with me full-time, she suddenly reappeared, fighting for custody despite her history of instability. A legal battle ensued, but ultimately I was awarded primary custody, and she was granted seasonal visitation. For years, she made little effort to be in our son's life. She rarely called, never contributed to travel costs, and repeatedly missed visitations. When she did speak with him, he often ended up feeling sad and conflicted. Despite this, I held out hope that we could establish a stable co-parenting relationship for our son's sake. That hope was my mistake. This past winter, my son, who had just turned 11, expressed missing his mother. I reached out to her and, believing she was making progress in life, arranged for him to spend 2 weeks with her over Christmas. I even met her halfway for the handoff, thinking this could be a step toward a better dynamic. Then, the night before I was supposed to pick him up, I got a text. "Josiah has decided to stay here. He's not coming back." I was stunned. I immediately objected, citing our custody agreement. She refused, claiming I wasn't affirming his feelings. When I insisted on speaking with him, she delayed for 2 hours. When I finally got through, my son seemed torn, saying he wanted to see his mother more but understood he needed to come home. Then, mid-conversation, she took the phone. The next time I called, he had shut down, repeating, "I don't want to talk right now, I just need space." Words that didn't sound like him at all. Realizing what was happening, I informed her that if she didn't return him, I would have to call the authorities. Her response? Threatening to file a restraining order. I thought there was no way she could, given that I had a legally binding custody order and that Texas had jurisdiction over my son. But I was wrong. I drove 9 hours to Wichita, Kansas to try to get my son back. The police reviewed my court order but told me it wasn't enforceable because it was out of state and didn't explicitly authorize law enforcement intervention. They offered to ask her to return my son. She refused, claiming she had safety concerns. The police said I'd have to go to court. As I scrambled to hire a lawyer and get a judge to sign a writ enforcing my custody order, she struck first, filing a protection from abuse order against me. The allegations were absurd, claiming I had choked my son and given him alcohol. It was pure retaliation, but Kansas courts accepted it without question. The PFA effectively blocked me from contacting my son and overrode my custody order. Texas still had jurisdiction, but that didn't stop Kansas from helping her. The judge not only. Story 13. I live and work in Tennessee, United States of America. There is a decent amount of preface here, so please bear with me. On New Year's Day of 2021, I hit a stopped police vehicle that was in the rush lane of Highway I-24 that runs through Nashville. It was raining and I thought the blue lights in front of me were on the shoulder. By the time I realized, my brakes were not enough, and I hydroplaned into the back of this stopped police cruiser. I will not make excuses. I was tired, and it was raining hard, and I should have stayed where I was, instead of trying to drive home. Very luckily, no one was in the vehicle I hit, as the officer whose car I hit was dealing with a traffic stop ahead, leaving myself the only person involved in the accident. I barely got out before I was tackled and asked what I was on. I was sober, passed field sobriety tests, but I did have a small amount of marijuana in the car with me that I immediately disclosed when I noticed they were already searching my car for stuff. They charged me with a misdemeanor failure to exercise due care, as well as a simple possession citation. I fully accepted these charges. I have never been involved with the police or law enforcement or anything in my life. I never made any attempts to deny what happened, because honestly I was young and dumb. And that was one of those moments in your life where you thank everything that no one else was involved, do your punishment, and learn to be better. Because of coronavirus, our court date got pushed several times, but we finally went to court in June of 2021. When the judge heard what had happened, and that the vehicle I hit was stopped in the rush lane, she dismissed the misdemeanor charge entirely. I would go on to get clean, pass my drug tests, and get the simple possession charge expunged in late 2021. All seemed fine and dandy. Until about 2 months or so after we went to court. August of 2021, I was pulled over for speeding. The officer ran my plates and discovered 2 outstanding felony warrants for my arrest for failure to show up to court. And the actual felonies? 2 counts of reckless endangerment with a deadly weapon. I ask him if he has any more details. He tells me the warrants say I failed to show up in court on the same day, at the same time, in the same courtroom before the same judge that I was in court with that June. I told him I had the receipt from that day in my glove box, even showed him the exact day, time, courtroom, judge, everything. I had no idea what was going on, but I know he was doing his job, and that there is nothing he could do. I didn't fight, went to jail. My car got towed. My parents scrambled to bail me out the next morning. $300 to get the car back, $600 for the bail bondsman. Fast forward to when we go back to court, the same judge asks how I want to go about the charges and is about to dismiss me when I ask her what happened. She is confused as she looks at the charges, and I tell her we were there in court with her that day, and after a moment, her face changes, as if she has had a realization. She tells me that they did not know about the charges at the time we went to court, even though that was when we were supposed to be there for them. Apparently they did not know about the charges at the time, because the felonies were filed 7 days after my wreck happened, and these charges were filed by the Tennessee Highway Patrol. So the night of my wreck I was charged with a misdemeanor and a simple possession charge, and then 7 days later, the Tennessee Highway Patrol filed 2 felony charges. All the judge gave me was a small apology, and then we proceeded to court a few months later. I ended up going with judicial conversion per my lawyer, and did a year of probation in exchange for expunging the charges at the end. I guess the reason I am typing this is to ask, is that how things go? I still feel like I was wrongfully arrested, spent a night in jail for something I didn't do, and was forced to pay at least 2 times the amount of money this would cost normally. That's part of the reason I feel so bad. I am very fortunate that my parents were able to help bail me out, but that was their money they used to help me, and I feel like I didn't deserve to be arrested because the court didn't know about my charges. Story 14. Last night I was woken up by a knock on my door from the sheriff. He explained I was receiving an injunction, restraining order from a girl I ghosted a month ago. She accused me of stalking her and hacking her phone, none of which I did. Some background: we met through a group chat and hung out a few times to smoke. We became platonic friends. We first hung out in June or July, and we hung out 4 or 5 times, and the last time we hung out was in August. She has major anxiety and depression, so I didn't want to continue seeing her, so I just stopped responding to her texts. She continued blowing up my phone with 10+ paragraphs of text in September, and I just never responded, haven't talked to her since. I treated her as a friend. I was nice to her, I bought her dinner, and I cooked for her. Now I have to go to court next week to fight this restraining order. And the packet I received from the police includes all the info and documents she provided as evidence. It's included 5 pages of her handwriting, explaining things, but I can barely read her handwriting. She wrote about the times we hung out, claimed I hacked her phone and bank. She includes a bunch of screenshots of her phone's data/analytics explaining things, but I don't see any evidence of hacking or any connection to me. She also included a screenshot of phone calls, claiming I prank called her, but the number isn't mine. There's no text messages or any real evidence of me stalking her or doing anything bad. Just 20 pages of her phone's analytics/data and a few screenshots of phone calls that don't show my number anywhere. I screenshotted the last few text conversations we had, where she was blowing up my phone. I plan to print them out and bring them to court. My question is, do I actually need a lawyer? It seems obvious to me that this will be thrown out in court. There's no real evidence. What can I do to protect myself? Should I file a restraining order on her? Do I counter-sue her? Too long. Didn't read. A girl I ghosted filed a restraining order against me with no real evidence. Do I need a lawyer, or will providing text conversations be enough? Edit. I will talk to a lawyer on Monday and get their advice. Update. She didn't even show up to court and it was dismissed. I haven't heard from her at all and she remains blocked. It all worked out. Story 15. I am writing on behalf of a family member who is in the middle of a very bad divorce. The story will be in first person to make it easier to write. The background: the manic ex-wife, Mew, has a history of manic episodes. When she gets angry, she will turn into a complete typhoon of yelling about everything that made her angry for the past 5 years. And before you start yelling about mental health, I have begged her to get help, but she refuses to believe she has issues. I have recently been laid off of a very high-paying job, and unfortunately, due to her false allegations, I am facing a pending felony charge and have been unable to obtain a job or decent representation. Based on our tumultuous history, every argument we have I record on my phone, or they are recorded on the house cameras. Now the story: first charge. This past summer has been extremely rough. I was laid off, the car and fridge broke in the same week. One day she came home from an outing with the kids. She was having trouble with the digital lock, but was able to enter the house. She initiated an argument, saying I changed the locks after she managed to get into the house. I asked, how could you get in if the locks were changed? Unfortunately, my logic escalated this into a level 5 argument, so I retreated to the basement with my visiting mother. Within 30 minutes, her mother shows up and starts yelling that I am an abuser and will not win. I was completely confused and asked, did you tell your mother I hit you? She responded by saying, he has never hit me, he knows better. I asked my mother to take the kids upstairs. She then chases my mother and calls her names. My mom has done everything to support our household, and the Mew calls her a female dog and a person who engages in intimate acts for money. My mom and I settle the kids, and eventually we make our way back to the locked basement. The manic ex-wife and her mom walk around the house to access the basement from the exterior door to continue the argument. I told her mother to leave, she is now trespassing, and my mom to call the police. The manic ex-wife and her mom tried to harm my mom. I insert my body in between them to give my mom time to call the police. Once they have been called, she tells her mom it's time to go. Her mom leaves. My mom and I go upstairs to check on the kids. She, once again the manic ex-wife, follows us. The manic ex-wife proceeds to push me into a wall, continuing to call me names, and throws my phone. I have been recording every interaction at this time. At this point, you can imagine the emotions I am going through. She has lied on me to her mom, called my mother a female dog, has yelled at the children, tried to harm my mother, repeatedly hit me, and now has thrown my phone. Thankfully, it was still recording. I was able to control myself with some level of restraint, and I bound her hands and told her I will not let her go unless she promises not to hit me. Eventually she did agree and I let her go. The police show up and tell us both we can file protective orders. I had intended on filing an order in the morning, but she beat me it and filed that night. The manic ex-wife claimed that I choked her, felony punched her, I physically threw her mom out, I abused the children, and my mom helped. Remember, I have this entire incident on video. I told the judge I have video of the entire incident. He did not allow it as evidence, since it was not submitted by an attorney. Fortunately, the judge at this time was able to read body language and felt that the manic ex-wife did not prove her case as well, and I was allowed back into the house. I continued living in my basement, she continued living in the master bedroom, and the kids had the run of the house. Second charge. Over the next few months, she would leave the house early in the morning and come home late at night. I did not ask where she went, nor did I care. My mother refused to come back to the house, which is understandable, but would visit when we had to make court appearances. On this day, the manic ex-wife was not home. My mother and cousin came over to help me clean the basement and move a few heavy items. While they were continuing to work in the basement, I walked my puppies. The kids told the manic ex-wife my mom was in the basement. She yells, "I want the female dog out of my house," and proceeds to call the police. My youngest, under 7, goes downstairs crying to my mom to let her know.